All right, you guys ready to begin?
Sure.
All right, so I'll just reiterate for the people who aren't already here. I spoke about a month or so ago here, covering basics of estate planning, starting with probate and moving into trust planning, what trusts are, generally talking about taxation. And then we promptly ran out of time. The library had to close and started a little bit too late to even questions. So in order to accommodate those who came last time, I am starting with the stuff that we were not able to get to during the last presentation. And then after that portion is done, I'm going to go back to kind of the nuts and bolts of what we went through in the last presentation, just kind of moving things in a little different order. So since many of you weren't at the last presentation, you don't miss anything. And I think this will hopefully be a little better recording for the library as well. So again, my name is Ross Denherter. I'm an attorney here in town. I'm Yankton's city attorney. That takes up about 30% of my workload. The rest of the time, I typically devote to estate planning and transactional work. So it involves helping people piece together sometimes complicated estate administration, carrying out the plan that someone has laid or failed to lay after they die. I also help people put together plans for themselves and their own families. I also will help people then just handle transactions for their own personal business affairs and estates. I do a lot of real estate work, real estate title cleanup, and I do business formations and business related transactions as the primary focus of my legal practice. Got a couple of attorneys who work for me, so our practice does more than just those things, but that's my primary focus in the office. During this presentation, we're not establishing any type of an attorney-client relationship today, so if you have questions, just be advised that there isn't a confidentiality and attorney-client privilege in this space. So if you have something you want to ask that's more of a confidential nature, feel free to schedule an appointment with me at my office through my assistant, Mindy. She's the boss of my calendar, but she will find the time to get in. If you are doing an estate planning consultation with me, there's no charge for that. There's so much to gather to learn about what your options are. I don't think it's fair to send a bill and make people watch their watches while we're talking. You won't get a bill. It's your opportunity to learn, with the goal being, once you are armed with the knowledge, you can implement a plan of your own that fits your needs. And then, of course, we can establish an attorney-client relationship to build that plan. But do not hesitate to ask questions as we talk. I want you to get some mileage out of this. It's not very often that you can, plug an attorney with questions and not get a bill for it. So this is one of those good opportunities. Don't pass it up. All right, so test of technology here. This PowerPoint presentation is hard to see. I will do my best to read what's on the slides for you as well. All right, we're going to open with asset protection. Am I standing in a place where this can see me okay? Okay, so asset protection. What is asset protection? What are we worried about from the estate planning context? Basically, estate planning asset protection, I view as shielding your assets, or what I like to refer to as your nest egg, from unanticipated or unforeseen future debts and expenses. So it's the notion that you spend your whole working career building this pile of stuff. How do you preserve at least a portion of it? Kenny, come on in, Kenny. There's plenty of room for it. Do you need something to write with or write on? Yeah, all right, no problem. Okay, so asset protection is trying to hold on to as much as you can, no matter what might befall you. Now, there's some limits. You see this unanticipated or unforeseen future debts and expenses. There is no form of asset protection that we can legally use to shield your stuff from a debt or a liability that already exists. So if you ran into some school bus a year ago and you hurt a bunch of kids and you know that they're all lawyered up. Like, oh, Ross, please build me an asset protection plan that will shield all my assets because that lawsuit, it's a coming. It's too late at that point. The liability already exists. And if you try to shield your assets from those debts and expenses, law views that as a kind of fraud. You're defrauding your creditors by trying to stash all your gold in the chest and bury it in the backyard. So in the context of asset protection, there are some really powerful things we can do to shield assets, but it requires you to plan ahead. It requires you to try to do what you're going to do before the debts arise. If you're on the doorstep of the nursing home, or if you've already had that car accident, it's too late. All right, so what are the types of things that we're generally worried about losing our assets to? Well, one of the most common things is unexpected medical or financial calamities. People who find that their health insurance doesn't necessarily cover all of the aspects of their treatment that they need. You've probably heard stories about people getting medications that cost tens of thousands of dollars in the course of a year or even in the course of a month. That can have drastic financial consequences on a family. Business failures. This is the big one that worries the average person. It's why we buy insurance. Or the elephant in the room, one of the things that I think brought many of you to come to see us tonight, nursing homes. Nursing homes play a vital role in our society. I think we have good quality assisted living and nursing facilities here in Yankton, but they are expensive. A typical assisted living facility can cost as much as $3,500 a month. A nursing home, I believe Majestic Bluffs here in town, don't quote me, I don't work there, but it's my understanding that the starting bed rate at Majestic Bluffs private pay is around, I think about $9,000. And you can have rates using the full slate of services that is well above 10. I think I've seen as high as 11, 12, 13. Yeah, it's the full slate of services is outrageous. So that's a monthly bill, right? So that's a big potential future credit. Scares folks.
So back to that liability.
Yep.
Should most people have $1 million, $2 million, $3 million liability or what?
That's an excellent question, and the answer is really dependent upon what you do, what your current situation is like. And I could have an individual conversation with each of you about what I would recommend. Just be aware I'm not an insurance salesman. So, but of course, being a lawyer, I think I'm really smart. I have lots of really good opinions. I will give you an opinion, but what I would typically tell you is, as a baseline of defense, get an umbrella policy. So what that basically is, for those of you who don't know, is an umbrella policy covers excess liabilities. So if I'm in a car accident or I have some premises liability issue that arises, my car insurance or my homeowner's insurance is the first policy that pays. But as long as you have limits up to a required level, you can get a relatively cheap umbrella policy that will cover the liability over and above that. And that extra coverage is pretty cheap. So, it's taking us a little bit off track here. It's a great question though. And with the umbrella coverage, you only need to have your underlying limits at the minimum rate for that umbrella policy to kick in. But for like car insurance, I think it's typical that you would have to have $500,000 worth of loss limits, and then the umbrella would kick in up to 1 million, 2 million, 3 million, whatever you decide to buy. Each subsequent million is cheaper than the one that came forward because the risk of hitting it that high is lower, right? But umbrella coverage is not fair. So that's my 2 cents worth on that. All right, so let's talk a little bit about paying for the nursing home when it looks like we potentially are facing bills as high as $13,000+ a month. That's really high. So Medicare will only pay a small portion of that bill. And I'm using rough numbers with these slides. There's a lot more science than the summary that I'm explaining here. But generally about your first 20 days in the nursing home are covered by Medicare. After that, maybe the next 80 would be covered, but it's going to be dependent on how you go in to the nursing home. So suffice it to say, if you just show up to the nursing home with a suitcase and say, find me a bed, I can no longer do it on my own, you're going to get 20 days. That's all Medicare will pay. After that, you're on your own, because in order to qualify, you generally will need to first go to the hospital, spend 3 overnights, and then after that, you have to be essentially prescribed the nursing home by the doctor as a therapeutic placement. And that happens from time to time. My wife's aunt, for instance, had a double knee replacement, and they prescribed typical narcotic medications, and they caused her, for a brief period of time, to lose her mind. And she was hallucinating, and she could not live on her own. So during the period of her recovery, while she was on these meds, they put her in the nursing home. She was prescribed the nursing home essentially as a therapeutic placement. Medicare covered the entire extent of her need for that because it was a therapeutic placement. But if you are simply going downhill, your health is declining, your physical abilities are declining, and now it needs to be your home and there's no real likelihood you're going to come out, you can anticipate that those 80 extra days complements Medicare are going to be hard to get. So food for thought. But once Medicare is done, you are on your own.
Ross, I talked to a guy the other day, I heard it right from the horse's mouth. This man worked all his life. He had about 300 to 400 acres of land in Nebraska. This down by, almost south of here, about 30, 40 miles.
Okay.
When the nursing home got done, they took it all.
Yep. I've seen that too.
They took the whole works.
Yep.
And his kids asked, well, how did that happen? He didn't plan ahead, did he?
I was just saying, it requires a person to put some time and effort into it well before you actually need it. There are some really powerful tools. Now I'm going to back up and say there's no way to protect everything. You shouldn't try to protect everything. But for the person who's got some land, there's a way to protect the real estate. You can, I always like to describe it as you can protect the core of your apple. You can protect the core of your estate, the stuff that is most sentimentally valuable to you, the stuff that you want to guarantee no matter what passes to your kids. There's a way to do that. You cannot protect everything. And really, we shouldn't want everybody to protect everything, because the trade-off is once you protected what you protect and you've spent through the stuff you can't protect, the state starts to pay. And where does the state get its money? The rest of us. So it's only fair that you can't protect everything, you can only protect some, because all of the rest of us pick up that part. Off my soapbox. First lines of defense, just like with your car, if you hit somebody with it, your first line of defense is insurance. You can get long-term care insurance. It's worth looking into. It comes in all shapes and sizes. Now, I'm the first to admit that traditional long-term care insurance is not a very attractive thing to buy. It feels like a sucker bet, because you're giving the company a large check and you're betting that you're going to need it, and they're betting that you're not going to need it. And if you just die in bed some night peacefully at 95, never having to go into a nursing home, you spent a great deal of money with nothing to show for it. They won that, and they won that bet. You were the sucker, right? Also, as you get older, I'm going to fill this up here because I'm talking about it out of order. Okay. As you get older, the prices, the price you have to pay, your premium increases. So that makes it less attractive. As you get closer to needing it, they try to price you out of it. It feels icky, but there are a lot different versions than there used to be. But let me talk about the pros first. Certain long-term care policies, if you have them in place, The state will reward you by letting you keep more stuff before you qualify for Medicaid. They won't make you spend through everything. It's kind of a, I wanted to use an inappropriate expression. I can't do that. It's not a great tool for that because those types of policies are really, really expensive, but it is a type of policy to get. Long-term care insurance also gives you the opportunity to stay at facilities that Medicaid wouldn't pay for, both assisted living and nursing facilities. Not everybody knows this, but these facilities don't all look like standard plain vanilla nursing homes where you walk in, there's that faint odor of urine in the air, that kind of somewhat sterile medical environment that just feels like a people warehouse. There's a place up in Sioux Falls that my wife's grandmother lived for about 8 years. It's called the Inn on Westport. Shameless advertisement for these folks, but it's like living at the Embassy Suites Hotel. It's just gorgeous. It's got this big center atrium. They've got meeting rooms for families to have parties. Everybody lives around this big center atrium, and all year round, it feels kind of like you're outside, but it's this big kind of greenhousey environment, and it's a balmy 72 to 4 degrees all day, every day, all year round. Gorgeous facility. You can use long-term care insurance at a place like that. So it opens up your options. It can improve what your end-of-life experience is because you have more facility options available to you. There are homes, go ahead, I'm sorry.
This long-term care insurance, now do you get a monthly bill period? I mean, is this 95 or is it like a whole term policy where you can buy X amount?
It comes in both shapes. You can do it either way or some combination thereof. They come in all kinds of shapes and sizes now.
Okay.
I'll get to that.
Okay.
Home care is another option that generally is not available to you if you are just using, Medicaid. Long-term care insurance can give you the home care options, so you never actually have to go into a nursing home or an assisted living facility. One of the limitations of this idea, though, is staffing to do it. It's nice to have that as a benefit, but if you can't find the certified people with the skills and know-how who will actually come into your house, it's really just something that looks good on paper. Kind of the harsh realities. There's just simply not enough qualified people to provide that level of care to everybody who would otherwise be in a nursing facility. But long-term care insurance can give you a much better experience, therefore it can guarantee your results. If you know where you want to go, if someday you have to go into an assisted living or a nursing home, you can work it backwards. You guys accept insurance, which companies? All right, let's focus on getting something like that so that I can go to this facility someday. Difficulties. Long-term care is like life insurance. It does typically require some kind of health screening. In fact, it's been years since I heard of one that did not require some kind of health screening. It is very expensive. But one of the things that I've seen in recent years that really makes this more palatable, whatever you dump in, there are policies that you can structure so it will return your premiums if you don't use it. So it's one of those, if you don't use it, you don't lose it ideas, and you delegate or designate a beneficiary to receive what's left upon your death. So another way to look at that would be something like, it's kind of like self-insuring. You're taking your money and dumping it into this bucket to be used for your future care. But with that bucket, they buy you better or more coverage. So if this thing costs you $100,000 over the span of your life, it might provide you a grand total of $200,000 worth of care. But if you die, you don't use it all up, your heirs get that as a payable on death benefit like life insurance. So that makes it a lot more palatable to buy something like that. I know that there's lots of companies who've done stuff like this. So if you have an investment advisor, I encourage you to go see him or her, see what they have for options, just price it. Just see what you can get. You know, if you don't like anything you see, you can shop around to other people, or you can say, well, at least I looked. What other options do you have, Mr. Denver? We can talk about other planning tools that can help you protect core assets. As you get older, though, it does get more expensive. And due to age or health, it is possible that you can be or become uninsurable. So it's one of those things that you really ought to be locking in sometime no later than your 60s. If you're beyond that, it's pretty hard to get it at an affordable price if you can get it at all. But even if you're in that realm, you might as well look and see what's out there. It's especially easier to acquire if you start with a chunk of money, like, so let's say you have a life insurance policy, you don't think you're really going to need to use it, but it's got a cash value of $75,000. I've seen this before. If you don't need the life insurance, you could take that $75,000 and convert that cash value into some kind of lump sum, and then you don't have to pay a monthly premium. It's paid up. That goes to the question you were asking earlier. If you have a chunk of money, you can buy a long-term care insurance with it. And sometimes those types of policies are a little easier to qualify for based on your age or health conditions. Not as hard because there's less of a gamble. You're giving them a huge chunk of your own money to start with. So food for thought, price it, see what you get. If you want some recommendations of people you can go shop this with, I can give you lots of names. Given the fact that I'm a city employee doing this presentation at the library, I'm going to refrain from making any special recommendations amongst this group. But if you come in and see me on a one-on-one basis, I'm happy to give you some recommendations. There's lots and lots of good people who sell these in town. All right, so now the big problem. What if I can't afford or don't qualify for long-term care insurance? What then? Well, the bad news is you must sell down and spend your resources until you qualify for Medicaid. That's harsh because Medicaid is safety net insurance. It is there to make sure that people who have nothing don't miss out on care. And the reality is the nursing home is effectively just a very, very expensive landlord. You are renting a room and rent is expensive. What happens if you rent an apartment and you don't pay rent? Pew, he says. Yes, the landlord must be paid. You must pay rent or you get the street. So Medicaid, how does it work? How do you get qualified for it? If you are a married individual, you can hold on to quite a bit of income, but you have to readjust how that income passes through. If you have more income than that $3,435 a month, the excess income has to be used to pay for care. If you are a single individual, they'll let you keep $60 a month. Isn't that nice? These are pretty harsh rules. There's also asset limits. You can't qualify for Medicaid unless the value of your resources, your assets, are under a given amount. So for married couples, it's not, they don't make you become totally destitute. They refer to these rules as the spousal impoverishment rules, meaning they don't require your spouse to become impoverished before the state will pay for care, but they don't allow you to hold on to an awful lot. The idea is a spouse who's not in a nursing home can at least hold the minimum, which is $27,840, and they get to hold up to the maximum of 1/2 of your estate capped at $137,400. That's the grand total. It's a weird kind of mathematical formula, but for someone who's built a nest egg that's substantially larger than that, that will feel awfully harsh, and it will feel like you've spent through almost everything. And then whatever the state pays, so a single individual, you can only hold $2,000. A married couple, you can hold up to $137,400. But once the state starts paying, they keep tabs on the total that they pay. So even if they let you hold $137,400, Once the second of you goes into the nursing home or dies, the state will assert a lien against all of that and they will recollect what they've paid. So Caesar will eventually take back what Caesar's, I guess. So harsh rules. If you are a single individual, $2,000 essentially means they take everything. Right? You can only have $2,000. There are some exemptions. So this is a bit of a silver lining. If you are a married couple, they will exempt the value of your home up to a certain amount. I can't remember exactly what that threshold is. I think it's equity value no greater than $500,000. So if your home is worth more than that, they would require you in theory to sell it and buy something smaller. But you can't have equity greater than $500,000. If you are a single individual, the only way you can exempt the value of your home is if you have a doctor that's willing to certify that you intend to, and there's a reasonable likelihood you can return home, that your health can, that you can regain the ability to live independently outside of that environment. The longer that lasts, the less credible that opinion starts to look. If you have a doctor that certifies that you have an intent to stay home and you're likely to be able to do so, 1 year later, the doctor's opinion doesn't look very reliable to the folks in the Medicaid office, and they might start asking for second opinions. You can exempt your car, one car, only one car.
That's how old you gotta be to go on Medicaid.
There isn't an age limit for long-term care. You just have to meet the eligibility criteria, but it's Medicaid for a person who just has income below a certain amount. That's different than the Medicaid eligibility for long-term care that I'm talking about here, okay? So this is really just the eligibility requirements that overlay coverage for living in an assisted living facility or a nursing home. Does that make sense? They'll let you exempt your personal effects within reason. I know a person who actually has a Picasso hanging in their bathroom. If the state found out that person had a Picasso, they'll say, yeah, we're exempting your personal effects, but not that. Sell the Picasso. Does that make sense? But if you are just a person who has general household goods and furnishings, the state doesn't get into valuing up all the knickknacks and the dishes in the cupboard and clothing in the closet and furnishing and furniture. Generally, they'll leave you alone there. You can prepay for your funeral. Guess what, folks? Every one of you is going to die. And unless you want a pauper's burial, you might as well pre-plan your own funeral. It's a nice gift to your family. It doesn't count against you. You prepay for your funeral as long as you set it up right. Funeral homes all know how to do that, so it doesn't count against you. So go have a consultation at least. Take that burden off the shoulder of your children. All right, so any questions about Medicaid before I move on? It's a really complicated program that I just explained, very minute, or I shouldn't say minute, very broad scope, 10,000 foot view detail. I can go into it deeper if you like. Is that a good enough explanation for you guys?
Yeah.
All right, so if you don't want to have to spend through everything to qualify for Medicaid, so this is for the person who's looked into and long-term care insurance isn't an acceptable alternative. We're looking for a way to try to protect that core of our stuff. How do we do that? Well, it gets down to the basic rule of debtor-creditor law. It's a very simple rule. Whatever is legally mine, my lawful creditors can seize or sell. That's the basic rule. And Medicaid works under those same principles. Any resource that is available to you must be used to pay for your care. That's the basic rule of debtor-creditor law. So if we're going to try to shield assets, we must modify the way we own our stuff in order to do that. Titling matters. The way we own our stuff must change. So how do you modify ownership of something so it's not legally yours? Does anybody have an idea? You're one step beyond where I'm going. So if I'm gonna give something up, what do I gotta do with it? Yeah, you gotta gift it, right? Gotta. So what did I do? Hold on. Okay. You gift it. Changing the title meaning you're gonna put somebody else's name on it. Yeah, all right, so protection by gifting to a person is problematic. I am not generally a fan of someone coming in who says, I want to gift my home to my kids. My friends told me I don't have to, I'll never lose it to the nursing home if I just put my kid's name on it. The problem with doing that, folks, is once you give it away, it ain't yours anymore. You lose control over it. The other thing that happens is loss of stepped up basis. Now, this is opening a bit of a tax can of worms here. So let's cover the last one first. You guys understand what I'm getting at here? If you gift it away, it's not yours. Let me tell you what can happen with this. Basic rule of debtor creditor law. Whatever is legally mine, my creditors can seize and sell. I have a client who gifted his home to his 4 children about 2008. This individual, very simple. Deeds are cheap. I can do a deed for $50, and then the recording fee is $30 at the county. Under $100, you can get your property out of your name. He gifted his home to his 4 children, 25% each. Well, about the same time, one of his 4 kids was involved in a car accident, had a back injury, and in the recovery process, briefly and accidentally got himself addicted to pain medication narcotics. He didn't want to be a druggie, so he forced himself off, but he's one of those folks that was susceptible to addictive behavior or breeds other addictive behaviors. He weaned himself off the pain medications by switching to alcohol. He was medicating with the beer can. And, he was a really nice, fun guy. Everybody liked him. So everybody around him tolerated the fact that he was drinking all day. But when he had nobody else to drink with him, he had nothing better to do but feed the video lottery machine. And he had really good credit. So in a brief period of time, in order to try to win back his losses, he exercised his credit and got a bunch of credit cards and cash advanced them all and lost all of that gambling and stuck his head in the sand for a brief period, I think around a year or two, didn't bother to file any tax returns, stopped tending to his businesses. By the time the dust settled, the IRS went after him. So he had racked up about, as I understand it, I didn't know he could do this. He racked up $250,000 in credit card debt. When the IRS finally came to him and said, enough of this, you're in trouble now, there was a lot you should have done and paid and you didn't, they slapped $250,000 federal tax lien against him. And then when his wife realized the extent of what happened, what do you think she did? She filed for divorce. And you don't think a divorcing spouse is a creditor, you just experience a divorce and you will see firsthand the worst kind of creditor is a scorned spouse. So all of that happened to this one guy in a reasonably short period of time, very likable guy, very trustworthy guy before this all happened. And he, when all this happened, is the proud owner of 25% of his parents' home. All of those creditors, through the eventual bankruptcy process, asserted a claim against his 25% interest in his property. And through some very creative lawyering, mom and dad did not have to buy that 25% back, but in order to prevent the need to buy that 25% back, they had to take their divorcing daughter-in-law and move her into their home for a period of 6 months in order to claim that home as her homestead in that pending divorce and bankruptcy. So that was, I think, as cruel as having to buy 25% of that property back. But that was just one example of the harm that can be caused by simply giving your home to your children. You can control to some extent what happens in your life. You cannot control what happens in the life of somebody else.
But he did ruin the other 3.5.
No, because he could have, but one thing he did do was he converted, when he conveyed that interest to his kids, it wasn't joint tenancy, it was tenancy in common. So literally that son's interest was only 25%. If you have joint tenancy, everybody owns everything. So it's a messy, I'm sorry, I'm getting way too far in the weeds with real estate law, but that one could have been worse, but it's a good example of where one thing goes wrong, everything goes wrong. And it's nobody would have thought a year before this that this would ever happen to this guy. He had a very successful business and lost it all, and caused a huge problem for mom and dad in terms of asset protection and recovering their home. So the house was, I think about that time, was worth about $275,000. So, I mean, if they had to buy 25% of it back, it wouldn't have probably broke them, but it was free and clear. And they decided that the lesser of the two evils was to move their soon-to-be ex-daughter-in-law in with them for 6 months in order to avoid that. Yeah. Simply gifting is not always the answer. Stepped up basis. Who here is familiar with the concept of basis and gain? Not seeing any hands, so I'll give you kind of the basic summary. Basis is what you pay for property, or what it's worth on the day you inherited it from your family. Basis sets the benchmark for measuring capital gains taxes. The land is let me just assume we're talking about a house. So let's say I bought a house for $100,000 back in 2010, and now if I try to sell it in 2022, I think I could get $200,000 for it. The difference between what I sell it for and what my original basis is my gain. That's the profit on what I made on that by simply owning that for 12 years, right? That gain is multiplied by my capital gains tax rate when I file my next tax return. And whatever that result is, that's the size of the check I got to write to the IRS. So capital gain stinks, nobody likes it, and there's lots of ways to try to defer capital gains so you don't have to pay it, but there is a gift right now in the Internal Revenue Code. It's called the step-up. I mentioned earlier, your basis is what you pay for it or what it's worth when you inherit it. It's because when you inherit it, you get a new basis equal to what that property is worth on the day you die. So let's say I bought that property for $100,000 back in 2010, and then in 2045, I end up dying of a heart attack, and now that property is worth $500,000. And my gain, huge number, right? It's $400,000 worth of gain because I paid $100 for it, now it's worth $5. That $400,000 worth of gain, because I died and my kids inherited it, they get a new basis equal to $500,000. It wipes away all of that taxable gain like it never existed. Magic. So if you gift, you lose that. Big for your heirs. It's a big issue with farmland because farmland depreciates so aggressively. I've seen a lot of families really upset because they heard at the barber shop or the beauty salon that, you just give that property to your kids and then you won't lose it to the nursing home. But someday the kids don't want it anymore after mom is dead and they want to sell it. And like, holy cow, we've got a huge amount of gain that's built in there. And we lost that step up in basis because mom gifted it to us. So gifting to a person causes the loss of that step up in tax basis. Sorry if I put you to sleep with that. Anytime we talk about taxes, it gets complicated and boring. All right, there's another way. This is a more complicated form of estate planning. And normally this would be something I'd cover at the end of the presentation after I've taught you a little something about trust. But there is a form of living trust that you can use that functions like you've gifted to your children. Really a neat tool. I tease out of these. I think they're the greatest things since sliced bread, but it's still not perfect. In an asset protection trust, You can maintain control over what's gifted, whereas if you gift to your family, you can't. Right? If you gift it to a trust, there's a way to retain indirect control. If it's structured right, you don't lose that step up in basis. That's a big deal. But if you're going to use a trust to shield assets, if you want the benefit of the gifting to a trust, there are certain rights that you have to irrevocably give up. So if you've heard of the concept of an irrevocable trust, there's certain rights you don't have to give up, certain rights you absolutely do. It's legally mine if I can get to it and consume it. So if I'm going to use a trust to shield one of my core assets, I'm going to take my thing, my land, my house, whatever. I'm going to dump it into this trust, and the trust rule book is going to say, whatever this trust holds, it can be reinvested. What I mean by that is it can sell what it holds, and it can use that money and buy something new to hold, but it can never give me that money back to consume. Otherwise, my creditors could force me to do that. Could force me to cash it out and pay them. Medicaid would say it's an available resource that I would have to consume. So I have to give up the ability to consume what I put in that trust. That's why it only works to protect your core assets. The stuff you want to make sure that the stuff you want to guarantee is inheritance for your family. Got to be stuff that you never intend to consume. But you get a much better result than just gifting to your children. Any questions about that? There's some complicated theories I'm throwing out to you here. The other rule or the other compromise that you have to live with for this to work properly, you cannot serve as your own trustee. So the trustee is the person who's in charge of the trust. Think of the trust as like a wagon or an entity that simply owns stuff. Someone has to pull that wagon. We call that person the trustee. In an asset protection trust, that can't be you. And that makes it a little harder to structure this. You got to pick someone you implicitly trust, manage this for you. You can boss them around. You can hire and fire that trustee. That person can't be you.
Yeah.
Huh? Oh yeah, it's great. You can have indirect control. You just can't do it yourself.
I've got a question.
Yeah.
So somebody owns a house and you get a trustee. Now, you bought that house 40 years ago, like you said, you paid $100,000.
Sure.
And you die. The trustee, there's the kids want to sell it.
Sure.
So they sell it. What do they pay taxes on?
As long as they sell it upon or near or at the time of that, as long as that sale is at the time of the ordinary administration of the deceased individual's trust or estate. If it's structured right, they don't lose that step up the basis, so they would pay zero gain taxes on it.
Okay.
It's a great benefit if you've held an asset for a very long time.
But if they rent it out and appreciate it.
I wouldn't even say they're in trouble, but they start calculating when they own it. They start calculating the tax on their profits based on its value on the date they inherit.
What do you do with the will? So the city just has lots of mutual funds.
Sure, same thing with that. If your kids inherit the stocks, there's a step up in basis and all that stuff. So inheritance is always better than gifting. Always.
I don't have kids. I got 3 brothers and a sister.
That's okay. Doesn't have to be
Very
just
long live, so I'm not going to live everybody. But I've already got a will that says equal shares to all 4, but are they still going to have to pay? If they have to be any kind of inheritance tax?
Where do you live?
Yeah.
Okay, I just want to make sure you're on the north side of the river. Yankton has no state level death taxes. And at the federal level, taxes are only imposed upon estates for an individual greater than $11 million. Now, at the end of 2025, the current rates are going to drop down to what they were before the last round of tax cuts or tax breaks for state taxes. So at the end of 2025, a single individual will be able to pass about $5.5 million without triggering any federal estate taxes. So we're lucky that we live in South Dakota. If any of you, do any of you live in Nebraska or Iowa? You're in Nebraska. Oh, I'm sorry.
I know, me too.
Okay. Do you have children?
Well, not that time usually now.
Okay. Well, let me back that up. So the tax rate in Nebraska is only 1% as long as you are passing assets to your descendants. All right. So that changes things. If you're going to,
Get a dollar.
you don't have to give them $1 if you don't want. No, you don't. You don't want them to have anything, don't give them $1. Come on.
See,
We should talk later, yeah.
but I'd like to hear.
I have a slide way farther into this that relates to taxes, but it's at the very, very end. So if we simply run out of time before we get that far. What? Okay, we'll go into trust structure in a little bit. This is normally, like I said, this would be at the end, so you already have some knowledge of trust. But because I wasn't able to cover this last time, I wanted to cover this in the front end. So this is a special kind of living trust. This is not your basic estate planning vehicle. This is a special trust that is simply designed to shield just the core of your estate, your key assets that you want to make sure your heirs are guaranteed to receive. It's a lockbox. It will hold stuff safe. What's up, man? You know, it's good. I haven't seen you for years.
You want to go over everything?
Yeah, hold on. Let me back up a few slides. You're just gonna have to buckle up, man. Yeah, no worries. Okay. This trust is irrevocable. There's aspects of it you can't change. Those core aspects you can't change are you can't serve as a trustee and you can't consume the assets that are put in it. Those rules are unbreakable, but there are other aspects of that trust that you can change, like who gets your stuff after you die and how they get it. You can still change your will. So as an estate planning vehicle, as long as you're comfortable that what you put in it is the core that you want to protect, is a useful tool for that. There's enough flexibility to account for future changes you'd want to make regarding what happens to it when you die. Yes.
If you own your home and you put your home in a trust, say your home is worth $100,000.
Sure.
And you decide that you want to buy a $200,000 home. So you sell that, but it's in a trust. Can you sell that?
It's in this trust. This trust has restrictions on it. A typical basic estate planning trust doesn't have these instructions, doesn't have these requirements.
Okay.
But if this is the trust that you want because of the protection it provides, that's an excellent and difficult question, because you can reinvest what that trust holds, but you cannot consume what that trust holds. So you can sell your house, take the money and buy a house of equivalent or lesser value, but if you need more money, you would have to contribute additional money into the trust to combine with the sale value of the house that was less, so that you have enough money in the trust to buy the $200,000 property. That makes sense?
You just pay cash.
You can. The whole point is whatever's in the trust first can be reinvested, but can't be pulled out. So if you start with your home in that trust, all you have is a $100,000 thing. You turn it from a house into $100,000. You need to put more money with it. So you got to put an additional contribution into that trust.
So if I pay cash, the other $100,000.
Yeah, that's how you'd have to do it.
Yeah.
Yeah. But it gets, the reason that's a complicated thing to do is the next slide here. Unavoidable problems of gifting to protect assets from the nursing home. So this is both the trust and gifting to one of your children or to a niece or a nephew or somebody else in the family. When you gift, it creates eligibility problems for Medicaid. Now, one of the core purposes of gifting is so that you don't have to spend through everything before you otherwise qualify for Medicaid, right? We're trying to put ourselves into a position where core assets are going to be able to be passed on to the people we care about. So gifting is made problematic depending upon how long ago the gift was made. So here's your crucial time frames. The look back date that's triggered from the date that you're both in the nursing facility or assisted living facility and you complete the application for Medicaid. So if I'm in a nursing home and someone brings me this 60-page application saying, figure out where you're at, qualify for Medicaid because your money's running out. That will trigger the look back. And the look back period is 60 months from the date that I fill out that application. So if you are going to gift your home into a trust to try to shield it, or if you're going to gift your home to your kids, despite the risk that may pose, we talked about earlier, you have to do it at least 5 years, at least 60 months before you would ever apply for the state to help you. Remember, the look back date isn't the date you move into the nursing home. It's the date you move into the nursing home and complete an application. So in that framework where you have a house that you moved into this trust that's worth $100,000, and you live in that house for 5 or 10 years, and then you decide to sell it, but you're going to need to put in an extra $100,000 so you get that $200,000 property that you want. That additional $100,000 that you're putting in also has a 60-month look back. So if you're going to add property to the trust later, you are restarting that clock with respect to the new thing that you're putting in the trust. That's why that's complicated.
Just for the 100?
Just for the 100, yeah. Each new addition would have its own separate look back, but that does cause some real problems. I typically recommend for people, when you're setting this up, figure out what the core of your apple is that you want to try to protect. What the core of your apple is that you're trying to protect. Right away, commit to protecting that. And if there's something you intend to do, like upgrade a house later, add more money to your trust up front. So when you're ready to do that, it's already in the trust. Because trusts can own more than real estate. They can own bank accounts. They can own brokerage accounts. You can move other things than real estate into that trust. So you have that core already in the trust with one original 60-month window that you have to get beyond.
So that would include investments also.
It can, yeah. Just remember, if you think you're going to need the investments to live the life you're accustomed to, that's not the thing you should put in that trust because you can't consume it. So investments or cash are really hard to protect using a trust because if all you get is the income that it generates, which you can draw out, I don't know about you, but my bank accounts for the last 10 years or so have earned a pittance worth of interest. That's not enough to live off of. And if I think I'm going to need to consume the principal value of those funds, it's stuck in that trust. I can reinvest it, but I can't pull it out. So you would really need to be thinking long and hard about the use of that money. If it's earmarked to upgrade a home later, great, because that's how you were planning to spend it. But you can't pull that money out and take that bucket list vacation around the world. That make sense?
I have a will that was made in California. Is it legal here?
Probably. I have to look at it to confirm, but likely.
LegalZoom.com, due for $74.50.
Yeah, I'm sure it was a sweet deal.
Bureau is the co-owner of the company.
I tell you what, I've seen some LegalZoom documents. They're not terrible. When you get into more complicated estate planning with LegalZoom, the problems that you run into aren't the quality of the documents. It's that you don't know what you don't know, so you're not entirely sure if you're filling out the questionnaire, all the bubbles and everything right, so that kicks you out a document that does what you want it to do when you die.
Well, I have 3 brothers and a sister, and I want to give them every equal share. That's what it says.
Sure. Yeah, and I'm going to bet dollars to donuts that will is just fine for what it does. When we're done with the asset protection, assuming I can somehow get back on track here without meandering down these little side trails so far, the real issue with the will has more to do with the process of administration, the cleaning up of your mess after you're gone, probate generally. Those are really more of the issues with wills. Wills are simple, they're easy to make as long as you're using a LegalZoom or a lawyer that's prepared it. It's likely going to be just fine, but you will typically be locked into the process for estate administration, the probate process after you die. A lot of people think that. That's just, unfortunately, that's not reality. Your will is actually admitted to probate. The court reviews it, confirms that your will meets the legal requirements, and then accepts your will. The judge appoints your executor or personal representative and blesses that person with the legal authority to stand in your shoes, and then the process of probate really begins.
So it's not really very expensive.
Yeah, it depends what's expensive. Typically, I don't mean to sound snarky with that. Traditional small town lawyers, it was once said that they could only make a living if they charge a percentage of a person's estate. And it's not uncommon around these areas to find lawyers charging anywhere from 2 to 5% to do your probate. I think that's highway robbery. When I first started practicing law and learning this area of the law in a practical sense, a lawyer that I really respected told me that the work is not any harder or different if it's a large estate or a small estate. So how is that ethical to take a 3 or 4% fee from a person who has $1 million estate? Why is that any more work or more challenging than if it's $100,000 estate? It's the same work, it's the same shuffle. The only way you can get fairly compensated is if you do it at an hourly rate. So I committed myself from there on out, I'm only going to do them by the hour. So I can tell you when I do a probate, it will typically land somewhere between $3,000 and $5,000, give or
So
take.
it's no way to avoid.
There are definitely very good ways to avoid probate, but again, you got to plan ahead, and a will typically won't do it. South Dakota has some generous laws. You might get lucky based on the value of your estate. You may be able to avoid probate just by virtue of what you own. But you need to presume that if you have stuff, when you die, you're probably going to go through probate.
Most of it's not.
Stocks, bonds, and mutual funds can escape probate typically because they're payable on death, as long as you set them up to be payable on death. We call those non-probate transfers to others.
That will say transfer.
Right, so those things will escape probate. Do you own your home? Okay,
I live in an apartment.
okay. Your estate may be structured in a way where you may successfully avoid probate. The state actually made it a little easier too. If there's some miscellaneous things that you own, it used to be the total value of your estate exceeded $50,000, you were hooked into probate. July 1st of this year, a new rule took effect. And as long as, if you own real estate, if the value of that real estate is less than $50,000, and if the total value of everything you have is less than $100,000, you can avoid probate. So it got a lot easier to avoid probate if you have a modest nest egg. But if you own real estate that's worth more than 50, you're stuck in probate land unless you do a probate avoidance estate plan of some sort, or if the value of your estate exceeds $100,000 in total. So it's jumping ahead and covering slides that I had planned later, but I don't mind taking the questions as they come. I just hope that it's a flow that still makes sense. Okay, so I have had a lot of experience with people who say, all right, so I'm not interested in doing a complicated trust. I want to try to push some things through to my kids. What if I don't gift my home to my kids, but let's just say I'm going to take my $200,000 home and I'm going to sell it to my children for or I'll sell it for $10,000. I should be able to sell my property for whatever I want, right? $10,000. Well, under the Medicaid eligibility rules, they have this concept of compensated versus uncompensated transfer. It's the notion that the property may be worth $200,000. Your sale is a legitimate sale if you sold it for $10,000, but the difference between its market value and what you sold it for is an uncompensated transfer. So it's compensated for $10,000, uncompensated for $190,000, and Medicaid will treat it as a gift for that difference. So there's not a lot of loopholes that we can use to try to wink, wink, nudge, nudge our way past the 60-month look-back period. Here's another thing that throws people off. I get this one a lot. Folks are very concerned about the nursing home. They've got grandma or mom giving $15,000 a year gifts to reduce the value of grandma's estate, so we don't ever have to spend all of grandma's money on the nursing home, because someone told them that you can give up to $15,000 a year. That's a tax rule. Everybody gets to do it. You give up $15,000 per person per year, and nobody has to answer for that. Who here has heard about the $15,000 a year gift? Yeah, a number of you have heard that. That's actually a tax rule. It's called annual exclusion gifting, and it is a really neat thing that the IRS lets you do, but it is a tax rule that's designed to minimize the need to file a gift tax return. So if I gift to my children $15,001, I now have to file a gift tax return reporting that gift to the IRS. That's what that is. It's because the IRS tracks the number of gifts you make over the course of your life and keeps a tally. I told you right now, you die after 2025, you can pass $5.5 million without triggering federal estate taxes. But what happens is when you die, they take your $5.5 million, they subtract the gifts that you made during your life that were over 15,000, and they say, this is the amount that you have left. So that's what that rule is for. It has nothing to do with Medicaid. So it is an IRS rule that a lot of people think they can use to push assets out of grandma's name or mom's name so that she doesn't lose it to the nursing home, when in reality, all they're doing is making $15,000 gifts that have 60-month look-backs on each one of them. So annual exclusion gifting is a terrible way to protect assets from the nursing home, because each of those gifts puts grandma or mom 60 more months away from being able to have the state pay for care. So be wary of that. It's not an effective strategy. The way it works is if you have a gift that's within this 60-month window, when you apply for Medicaid, the Medicaid folks will do one of two things. They'll say, get it back. If you've gifted money, I tell you what, it's really hard to get it back, because when you gift money to kids, they like to spend it. You can't unspend money very easily. So, so the way it works is if I have a gift that's made during that 60-month period and I can't get it back and use that money to pay for my care, so what the state does is they take the value of that gift and they divide it by the year, that current year's calculated average daily cost of a nursing home in the state. So if I have a $15,000 gift, we'll divide that by $268.21, and that will give us a number. That's the number of days that grandma or mom or whoever it is not going to be eligible for the state to pay for the nursing home after grandma has already spent everything else she's got. So that would call it the pass the hat stage. And we have to get mom or grandma past that penalty period before Medicaid will kick in. Really harsh.
Is that in the family? That's healthy?
They better, because if you don't pay rent, what happens? The nursing home will evict you, unfortunately, because it is not a charity, despite the fact that it is run typically by a nonprofit, tax deductible, charitable, religious institution. It does good. Okay. So how to avoid the nursing home spend down? Planning ahead. If you plan while your health is reasonably good, while your age is at a point where you're statistically unlikely to need care, you can do some pretty effective planning to shield your core. Typically, the best tool in the toolbox is that asset protection trust we talked about. There's also gifting to kids, despite the risks that it has. Some people are still committed to doing that. long-term care insurance, shop it while you can. If you're going into assisted living or the nursing home, it is too late to get a policy. All right, does anybody have any other questions about protecting assets, nursing home? I'm about to move on. Was anybody here at the last presentation I had? Okay, so now's the time I'm going to start retreading the ground that we covered last time. So I will not force you to sit through it again. If you wish to check out now, I won't be offended. But you're welcome to join and rewatch this material if you wish. No takers? Some people would find this painful. All right, keep going. You guys are free to hop up, use the restroom if you like. If you want, we can take a short break too. We've already been at it for an hour. Does anybody need a little break? Leg stretch, drink water? Okay. Making me feel like I might be interesting. All right, legal estate planning, generally. So this would typically be the beginning of my presentation ordinarily. So legal estate planning is an important part of preparing for your death because believe it or not, every one of you will die. If you don't prepare a plan, you get the one-size-fits-all plan complements the state. So I generally start with some basic philosophy premise that I think gets us started or pointed in the right direction. I think a good plan should allow you to control your property while you are alive and well, period. It should provide accommodations for you and your loved ones if you become disabled. This is an aspect of planning most people don't really think about until the lawyer forces them to. But believe it or not, we are all fragile meat sacks and we are all slowly wearing out and waiting for our time to check out. So the period of disability is real. Almost every one of you will have some amount of disability that afflicts you before you die. So it is important that you plan for this. Does anybody here remember the story of Terry Schiavo? Other than, of course, the people who sat through this last time. All right, Terry Schiavo was she was a young woman in Florida. This was the early 2000s. I believe this was going on. Yes, that's exactly right. That was a case of whether to pull the plug or not. This was a woman who was semi-vegetative. There were some videos that were played in the press because everybody weighed in. Congress weighed in on this, but it was a fight between a husband and this woman's parents. And she was on artificial hydration and nutrition, but she was living without like a respirator or anything. But she could not feed herself. It was all, machines that were keeping her alive. But over a 10-year period, there was a court battle as to whether she should be, in her husband's position, allowed to die dignified, or from the parents' position, allowed to continue to live the way she is in case there's advances in medical science that could bring her back. She was helpless. There's no way around that, but she did not provide any prior disability planning. So unfortunately, Congress weighed in. It was stupid. It was such an easy thing to prepare for. The reality is the quality of modern medicine keeps getting better and better. But the reality is that quality isn't doing a very good job of attacking chronic age-related disease. So as our bodies waste away, they can keep that ticker ticking, but they can't do a lot to keep us into a position where we have all of our faculty. There's no fountain of youth that's bringing us back to full capability. So we're living longer. We need to prepare for that time where we cannot take care of ourselves. So what do you need? Who has an idea? There's a couple different tools in the toolbox. What do you think?
We did advance directory. If we are to each state, then forget it.
Right. So there are actually two kinds of advance directives. One's called a power of attorney. That's basically a delegation of authority to somebody else to act for you. The other is a living will. Okay, a living will is a very poorly named legal document. It's not a will at all. It's a set of instructions that you leave for the medical providers to carry out if you can't make an informed decision yourself. It's basically a typical advancce directive living will. It looks like a check the box kind of a thing. You check the box that says, if I'm ever hooked up to life support, you can go ahead and pull the plug. There's no chance that I'm going to get better. And check the box if artificial hydration and nutrition, like the Terry Schiavo situation, is included within that concept of life support. So you're telling the facility whether they should pull the plug or not. So what? With the living will, yes. Now, by contrast, a medical power of attorney is instead a person that you are delegating, that you trust, to make an informed medical decision for you if you can't make it for yourself. So think of it in the situation where if you have minor kids, you get to make medical decisions for them until they reach the age of 18. This is the reverse of that. This is you potentially giving that same authority to your children to make informed medical consent decisions for you because you are at the opposite end of life and need somebody to make those decisions for you. I think it's, if you have somebody to do it, it's a far more flexible tool because your condition might not perfectly fit the box that you checked on that living will form. The other aspect of it that I really like is if I'm truly in a vegetative state in a hospital bed, if I've left that decision to my wife, she gets to decide at what point I get sent off. I might have told her my wishes, but I give you two examples of why that matters. One, if my wife feels like she needs to keep me alive on life support for another week so she feels better about the fact I'm not going to be here anymore, I'm vegetative in a bed, what am I going to care? I trust my doctor, but I love my wife. Let her do what she feels like she needs to do under those circumstances. The other is I've heard multiple stories, each of them shocking in their own right, where we have a medical power of attorney where someone was delegated to make informed consent decisions, and the hospital said, oh, following the car accident here, your husband, there's no way he's broken nearly every bone in his body. He's got multiple organs that don't appear to be wanting to work quite right. How about you sign this form? We'll unplug the machines. We'll get we'll get his body ready, and we can harvest. Share his organs with people in need. And everybody's well intended. We trust our doctors. I think they do a good job. But multiple situations where I've heard stories of, one of the sons was out on the East Coast, and it would be a few days before he could fly in, so we're going to keep Dad on life support until all the kids can be there to say their goodbyes, and then we'll let him go. Well, by the time that child gets here, vitals look a little better. Everything seems to be, maybe not better, but improved. Let's see what a few more days holds. More improvement. And over time, that little stepping up, just waiting and seeing is all it takes. And there is some measure of recovery. If you had a living will, the doctors are well intended, but they're not always right when they assume you're never going to get better. So the living will the living will would have meant death in those situations, whereas the medical power of attorney, because it was right for the family, meant that person came back. So I think it's better to have a flexible tool, let the family that you trust and care about decide. So that's my 2 cents, at least as it relates to the medical side. It's also important that you guys have a general durable power of attorney. The world doesn't care. The world is a cold and harsh place. The world doesn't care that you're tied to a hospital bed with tubes coming out and stuff. Rent's still got to be paid, folks. I mean, it's the bills, utilities. The world keeps turning, even though you are in a crisis situation. So the general durable power of attorney delegates your check writing authority, your ability to manage your affairs to somebody that you trust. It is an incredibly useful tool to keep your affairs tended to when you can't do it yourself. So these two together make the yin and the yang of disability planning. They're both very easy to create, which means they're also relatively cheap legal documents. They should be part of everybody's estate plan. even if your estate plan is fairly simple with just a basic will. You should have medical and general durable powers of attorney. Now, by contrast, if you don't have somebody well suited to make a medical decision for you, some families have that. You don't have somebody close. A living will make sense in that context because you've at least filled the gap. You've got a way for a decision to be made. But if you've got somebody, I think the far preferable tool is the powers of attorney. If you don't have somebody who can do the business side of it, as long as you have somebody that you trust to carry out, or like a bank to carry out your wishes after you die, you usually name that person as your power of attorney too. The bank is willing to be your power of attorney if they will also then seamlessly transition and wind up your estate after you die. So that is an option for those of you who may not have people well suited to do that. So food for thought. All right, so let's go beyond disability. Legal estate planning, if done right, again, getting back to my philosophy, it allows me to give what I have to whom I want, when I want, the way that I want, and also assure that my assets pass to the people or causes I love without unnecessary cost or delay. So again, that gets back to potentially avoiding the probate process if that's something that's important to you. So key to an effective estate plan, I view it as making sure that you are being proactive about it. Don't just rely on whatever the statutes say is supposed to happen to your stuff because you don't make your own plan. It's important that you understand what is going to happen with the plan that you have or don't have and why that will happen. If you're going to avoid probate, I want you to know why you're going to avoid probate. Or if you don't care, what the probate process actually entails. Then, of course, when we understand what's going to happen, it allows us an opportunity to brainstorm a plan if you don't like that. So essentially, your legal estate plan for in a paper trail context is building binding legal instructions for your heirs. When you die, you want to make sure that your plan will pass the way that you have laid it out. There's lots of different rule books, but that's what I call it. You need to have your rule book. Your will is a basic rule book. And it's supplemented by the Uniform Probate Code, which is a book this thick, hundreds of pages long, but it's tethered together by your will. So based on the different tools, you think about how to do this in a way that maybe speeds things up here. Let's play a game. Do I need a will or a trust?
Trust.
Really? I think we demonstrated with this gentleman over here, you probably don't.
I think it.
Right, in this day and age, I guess.
I would
choose.
I would bet a trust has more. Is it better?
Well, let's talk about what we really need. So let's take a very typical married couple, husband and wife. They own some of their stuff jointly. So we got a home, bank accounts. We've got assets with beneficiary designations. This would be life insurance, annuities, retirement accounts. CDs are typically POD. What's POD mean? Pay on death. What's TOD?
Transfer.
Yep, I don't know why we have two separate titlings for this, but PODs are bank accounts and CDs. TODs are brokerage accounts. Same thing. This is snootier. I don't know. All right, so this is how my estate is set up. And I own my home and my bank accounts with my wife. Everything else is payable on death. When I die, my home goes to my spouse automatically because she is a living joint owner on that property. My life insurance, annuities, and retirement accounts automatically pay to my spouse through the process of the claiming beneficiaries designations after death. Same with CDs, paid on death, transfer on death on my brokerage accounts. How about that will and that trust? Did I use those at all? I didn't use either of them. I could have had the world's best trust, but if my assets are owned like this, I didn't use them. Everything automatically transferred. So do you need it?
Well, I think it depends on the situation.
No. Yeah, and this is kind of a cheeky example to show that you really don't need to have a special will or trust to avoid the probate process, to efficiently transfer your stuff. But I call this planning for destiny. What you're doing is you're anticipating the order in which people are going to die. You are anticipating that the people that you want to have stuff are still going to be there when you're gone. What happens if I own my stuff jointly with my wife and we both die in the same fiery auto crash? Now we got a mess. Now we got a different way that things happen. So guessing fate, in my opinion, is a terrible way to plan exclusively unless you really stay on top of it. And in your situation, you've got a bunch of things already payable on death, that's okay. But if something happens to any of those folks, you want to get right in and change your designations so it still lines up with what you want to have happen to that stuff. Preparation for disability. Let me give you an example where this is problematic. So if I have life insurance payable to my daughter, and she's with me in the car and I get into a terrible car accident, I'm deceased and she's now disabled, you got a terrible problem because she's inheriting as a disabled individual who's now going to be dependent upon Social Security disability. The receipt of that inheritance makes her ineligible.
Oh,
Whoops!
until it's gone.
Until it's gone, sure. But there's a way, if you do a comprehensive estate plan, that wouldn't happen. Again, kind of doubling back to the first half of this presentation, basic rules of debtor-creditor law. If you can lawfully reach an asset, so can your creditors. If you name joint owners on your stuff, like the parents who named their child as a joint owner of their house, their child's creditors reached that asset. You missed that example, I think. Yeah, that was a great story. Don't gift property. Loaded with problem. Any question about my concerns with planning exclusively using disability, or I'm sorry, designated beneficiaries?
This couple that died in this fire, they owned a house,
Mm-hmm.
and they didn't have a will, didn't have a trust. Did
Yep.
they get it?
State does not get it necessarily. What happens is you get the one-size-fits-all will complements the state code. The legislature years ago made its best guess as to what the average person wants to have happen to their stuff if they don't make a will. And believe it or not, 60% of all people die with no plan. So this becomes the will a majority of the time. It's crazy when you think about it. They call that intestate succession. Yeah, you get the one-size-fits-all will.
So what is that?
I don't think you have a slide for it, so I'll go into that. Okay, so intestate succession works generally like this. If I'm married and my children are also my spouse's children, then my spouse gets 100%.
But if you're both gone, you get it.
Right, so I'm just kind of going through the list because it's a if-then sort of breakdown. If I have no spouse, it would presumably go to my children. If I have a spouse, but I also have children from a prior relationship, then things start to get really, really messy, and the state's best guess is really probably not a good fit for anybody anymore. But there's a splitting that occurs. So the surviving spouse gets a percentage of the estate that gets bigger based on the number of years that they're together, capped at 50% after 15 years. They call it the augmented estate. It's very difficult to calculate. Suffice it to say, it is a breeding ground for litigation between kids and new mom or new dad when their parent dies. So, fought over all the time. Okay, That generally creates it's a big problem if it's not a marriage, but there's been somebody that's been there living like a spouse for many, many years. There's no common law marriage in South Dakota. In fact, I think the only state near us that has that is Missouri. But getting to your question specifically, if there's nobody, it goes to your heirs. So your heirs work like this. If you have no children, no grandchildren, then it would go up a generation. So it would go to your parents. Your parents are gone, then it would go to your siblings, and then your nieces and nephews, and their children, and so on and so forth. And if they're all gone, you go up another generation. So it gets divided equally. It goes to your grandparents, who are presumably gone. Then it would go to your uncles and aunts in equal shares. If they're gone, it would go to your first cousins and their children, and so on and so forth. You keep going up, out, down the family tree until you find somebody who's still alive that's related to you, even if they didn't know you. There are businesses out there where their business model is, we'll help you find your lost heirs. And I tell you what, sometimes I've had to use them before, believe it or not. Going back a few years, Jim Getz, he used to be Yankton city attorney. He, kind of like me, he did the city's work, and then he did principally estate administration, estate planning, that kind of thing, and he had a lot of estates. Well, when he started practicing law, going back to the mid 1950s, he worked with another attorney who was serving as the executor of the estate for Monsignor Emmanuel Buska. Mr. Buska, or Monsignor Buska, was a first generation immigrant from Czechoslovakia, I think at that point in time. Catholic Monsignor, wrote his own will by hand in the 1920s, then updated it by hand in the 1930s. Very scandalous. He gave huge amounts of money to his beloved housekeeper, Minnie Bodine. But anyway, when he died in 1941, he gave his estate, other than the portions that went to me, to like 20 different charitable entities and family members. But the instructions were the personal representative shall hold my estate until its value reaches a size where it can pay out each of these gifts, because these gifts were sizable amounts for 1941. But he owned some land here in South Dakota, in North Dakota, Wisconsin, and Montana. Well, when Jim started practicing law, his law partner died in 1962, I think. That estate was still open. And that attorney was the executor or personal representative, so he ended up stepping in. So Jim Getz was the personal representative of that estate and never bothered to close it, never bothered to distribute it. So move ahead to his death in 2013. I'm stepping into now trying to figure out, how do I close out an estate for somebody who died in 1941 that still owns about $1 million worth of real estate in the states of Wisconsin and Montana, and the named individuals are long dead. Most of the charities were defunct and absorbed into other charities, so we had to utilize the service to try to figure out who the real heirs are, and we were successfully able to close out that estate using a service like that. So really, I read a law review article about it. It was a really fascinating case to be a part of. It's a cottage industry. I apologize for getting so far down the rabbit hole on that, guys. But finding heirs is challenging, and if you don't want things to get that ridiculous, just make your own plan, and then you don't have to worry about trying to track down your great nieces and nephews and wherever. But, all right. So if we're trying to build a comprehensive plan, and we don't want to just rely on fate with joint ownership or pay on death beneficiaries, how do we own them so that a plan actually attaches? How do I own my things to make sure my will govern it when I die? Any ideas? Not really a trick question. Just own it in your own name. If it's stuck in your name when you die, your will govern it. If it has a joint owner, your plan doesn't kick in, it just becomes owned by the joint owner. It's payable on death to a beneficiary, it just goes to that beneficiary. You want to put instructions on it. You want to make sure that all the ifs and thens that you want are covered, own it in your own name so it's governed by your will. So how do individually owned assets transfer to my heirs, assuming I have assets worth more than the $100,000 threshold of real estate more than 50? Individual assets equal last will and testament. Talked about this, you have the one size fits all will. The last wills and testaments equal probate, unless you can fit your way under that threshold. So who can give me a quick example or a quick rundown of what probate is? No takers? Anybody here been an executor or personal representative? Did you like it?
They had it set up perfectly.
Oh, good.
Didn't have to go through probate.
Oh, so you didn't actually go through probate? Okay. Did you have to go through probate? Did I help you go through probate? Okay. Yeah.
And you did it.
Well, thank you very much. The process works something like this. If you meet the threshold and it triggers probate, your will gets brought into the lawyer's office. The lawyer attaches it to a petition for probate that gets delivered to the courthouse. The court will review that will, make sure it meets the legal requirements to be a valid will. The court will accept that will into probate, enter an order accepting the will, identifying your heirs, and naming your executor. The executor gets a document called letters of personal representative, like your hall pass or your permission slip, to speak for the deceased. You take that document and you now have access to all the assets of the dead person. And now you begin the process of marshaling the assets. So you use that document and you go everywhere you can to find the stuff of the individual who died. So that document gives you the authority to gain access to bank accounts, brokerage accounts, at least to the ones that aren't automatically payable on death. It gives you the authority to sign deeds, to transfer real estate. You get to full on speak for the dead with that document. But with that power comes great responsibility. You have to prepare an inventory of all the stuff that's there. You have to prepare an accounting of all of the things that you do with the assets that are there. So you start with the inventory. This is the stuff that the deceased individual owned. This is what it's worth. And then the accounting is the corollary. Having started with all that, where did it all go? Down to zeroing out the account. And sometimes if you have a very tight family who has a lot of trust, you can skip some of these steps, save a little bit of money, but the process takes a while. How fast did we get the estate wound up for you? Take about a year?
Yeah, by the time the taxes.
Yeah, it usually takes about a year. It's a bit of a grind. Like I said, I do it by the hour, so the cost is somewhat contained, and if you can take shortcuts because the family cooperates, it translates into real savings. But it's public. Anybody who's nosy can go in and see your lifetime scorecard because those documents are available for public inspection. And you cannot go through probate without the help of a lawyer. It's unlawful. The court won't let you do it. So there's no way to completely avoid the expense of using a lawyer if you have to go through probate. Oh, let me jump ahead. Look at that. Slides that it showed you what I just explained. That'd be helpful. It is fully avoidable if you care. So how do you avoid probate without using payable on death beneficiary designations and joint ownership? What's the tool in the toolbox? Living trusts, that's right. So the reason that Trusts are legal entities. Like people, they have the rights to own property. They are incapable of death. So for that reason, they avoid probate. So what is a trust generally? We talked about it. I like to visualize it as something. Somebody want to take a stab at what a trust is? I think that is the very best metaphor for a trust. I can visualize it. Whenever I use the word trust, that's what I'm seeing in my mind. It is a legal entity that holds stuff and is governed by a rule book. The rules will dictate how your trust works and what legal benefits you get out of it. So let's talk about the breakdown of the trust a little bit. Someone's got to pull the wagon. The person who drags the wagon around is the officer. That is your trustee. That is the legal officer who manages the legal entity of the trust. If you are trying to make a trust for the sole purpose of avoiding that probate process because you got real estate more than $50,000 after your death, or the collective value of your stuff is greater than 100, you can be your own trustee. For a basic probate avoidance trust, you don't have to name a third party. So this is the basic, simple kind of trust. This isn't the asset protection trust we talked about earlier. There's no restrictions on who can serve as the trustee. So as long as you have your marbles, do it yourself. You get to play with all the stuff you put in your wagon with no restrictions in a basic probate avoidance trust. We call that person the beneficiary. You get to play with your own toys. Nobody can tell you what you can and can't do with it. So if you want to take your toys and go to Las Vegas, but the whole works on red on the roulette table, no one's going to stop you because you have the right to do that with that kind of a trust. But when you die, the rules will change. Now the trust looks just like a will. It's really two sets of rules. The rules that apply while you're alive, which are like, you can do whatever you want because it's your stuff, you get to control it. But then when you die, you get to specify where all the rest of your stuff goes, and the court never gets involved. The only reason you have to go through court with the will is because the court typically oversees the process of getting assets out of the deceased individual. A trust can't die, so the court doesn't get involved. That makes it super cheap to administer. The only thing you need a lawyer to do when you're administering a trust is transfer real estate if you own any when you die, because a lawyer needs to prepare a deed.
So you have a trust, you're dead,
You get to decide. That's in your rule book.
so you have to trust them.
Yeah.
So
Hence the name. Yeah, you do have that, and that is one of the most important decisions you'll have to make, whether you're using a will or a trust. Who is the person that you trust to carry out these instructions? Yeah, but whenever I do one, I'm going to assume that person is likely going to die. So I will always make my clients give me a deep roster. All right, we're picking your buddy Jim, but if Jim is gone before you or simply unwilling, who then? If that person can't, then who? And I'll keep pushing you until you run out of people you feel comfortable giving me, or until you give me a backstop like a bank, because banks can't die. Now, the people in the chairs might change, but they're always very capable and qualified. So having a deep roster is really important. And yes, a basic probate avoidance trust, you have the ability to change it later. I told you, even that asset protection trust that has those rules that you have to follow, you can still change the will that's built into it. You just can't change aspects of the rules that apply while you're still alive. The rules that say you can't be your own trustee, you can just pick that trustee, hire and fire them. And all you get is the income or the use of the asset without consuming the assets while you're alive. Oh, look at that, a question with an answer. There's generally two types of trusts. Who's familiar with the concept of a testamentary trust? Ever heard that term before? Many of you might already have this if you have a will that was generated at the time when you had minor children. How many of you have a will that says something like, I give everything to my kids in equal shares, but if I have a child that's under the age of 25, their share stays in trust until they reach that age, They can have access to it if the trustee says it's okay for important things like college education. That's called a testamentary trust because it's inside your last will and testament, and it doesn't get created until your will is probated. Does that make sense? Hence, it's a testamentary trust. Second kind of a trust is a living trust. This is the sort that we're talking about that would be used to avoid probate, because you create it while you're still alive, fill it up with your stuff, and since it can't die, nothing goes to probate. It also includes irrevocable trusts like the asset protection trust I introduced to you at the beginning of this presentation. They're both living trusts because you did it outside of your death or outside of your will. All right, I'm not gonna go through this one with you because it's too small to read from the back of the room, but this is a good example of a slide that you might enjoy seeing if you just want me to email you a copy of the slideshow or if you want to pick up a copy from my office. But this explains the different types of trusts and why you might want them, what they can do for you. For the average person that doesn't have tax-related implications, so estates of sizes less than $5.5 million, you only really need to worry about these two. There are lots of other kinds of trusts, but they're generally designed to obtain tax-related benefits, and therefore you have to give up lots of rights. So I would generally only ever encourage my clients to consider either of these two. So your basic probate avoidance trust, otherwise referred to as a revocable living trust, hence the name or the acronym RLT, that is designed to simply avoid probate. The asset protection trust is the trust that I talked about earlier in the night, where you have to give up certain compromises in an irrevocable way in order to gain the protection of the core of your apple. All right, using trusts, I really like it when you're building a plan because they can do a whole lot more than just making sure your stuff goes to your kids in equal shares. The planning tools in the toolbox are really exciting to me. This is one of my favorites. So picture this scenario, husband and wife, dad is like a typical bachelor, wife takes really good care of him. He doesn't even know how to run the washing machine. He needs somebody to really take care of him. That's me, right? I don't know how to run my washer and dryer. The worst kind of husband in that way. But I know that if something happened to me, I probably wouldn't make a very good bachelor. I'm probably going to find somebody to take care of me. So in this scenario, my wife and I have made this nice wagon full of stuff, and she dies. And there's someone who's maybe not with the best intentions, sees me as a vulnerable target. Oh, here's this eligible attorney out there who has stuff and he needs to be taken care of. And this person swoops in and convinces me I can't live without her. And the first thing she says is, this trust that you have, you care about me, right? Let's go update your plan so that if you die first, I need something to live off of. You need to, take care of me then. That's my turn. In that scenario, my wife would presumably be rolling over in her grave because I'm now modifying our plan to benefit this new person who's up to no good. If you are making a living trust, it is possible that you can lock in your plan in a way that if one of you dies first, the survivor can't change the plan to benefit a new spouse. Can't do that with a will because your will is strictly an individual document. Even if you guys made a will together as husband and wife and one of you dies, nothing prevents the survivor from going into the lawyer to change that will. The only plan that really matters in that context is the will of the last to die, if you care. So with a trust, you can lock things up. And really what you're doing there is you're modifying the rule under which you lose the power to make changes. You're simply saying the survivor can't make changes to this plan once the first dies, or you can leave a little bit of flexibility. You say the survivor can't make changes to this trust once they remarry somebody new or cohabitate or move in with somebody with whom they're romantically involved. That's basic remarriage protections. I think it's pretty effective. It gives certainty to the couple that this pot of stuff they've built together is earmarked for the kids. You're not taking either of them off the checkbook, but you're preventing their ability to change the will. Yes, that's exactly the way you think about it. So that's a really neat thing you can do with the trust that you can't do with a will. The other thing I like is with a trust, the ability to protect minor beneficiaries, the child that's under 25. I think most of us, at least us guys, can think back to the way we viewed the world when we were 18 years old, and if we had come into a pile of money, how would we have managed that? You know, at that point in life, I look back and I think, I thought my parents didn't know anything. If I had come into a pile of money, I probably would have bought a boat, probably would have bought a stereo that cost more than the car I was driving. It would have been gone. I would have wasted it because I didn't see more than maybe a couple weeks of money. Kids just don't understand the value of money until they have to live in the real world for a little while. So when you build a plan that says a beneficiary under the age of X, you get to decide what that is. They don't just get it. It stays in the hands of a trustee that you get to pick, that you trust, and the kid has to go to that beneficiary and ask for a distribution, and the beneficiary has to go to that trustee and ask for a distribution, and the trustee gets to decide whether it meets the criteria. Do you really need it? Is it a need and not a want? You know, that is something that you can only get from a trust. That's a trust that you would typically spring into effect after death, but it is a trust nonetheless, and it can do a lot more than just giving the stuff to the kids when they turn 18. Disabled heirs. Earlier we talked, I just briefly hit on the notion that if you have somebody who's disabled, you know, the car accident that takes your life and leaves one of your children disabled, and now they're going to be dependent upon Social Security. If they receive an inheritance outright, they get booted from that benefit roll until they burn through that inheritance. It is possible to layer into your will or in your trust a framework that says, I give it to my kids, but if one of them is disabled at the time of my death, their share stays in the hands of the trustee, and they can gain access to it for anything Social Security doesn't provide for. That's simple. They don't lose their disability benefits. They can still get their full inheritance. They just have to go through the gatekeeper trustee. Really powerful tool. I've seen that adversely affect 3 different families since I started practicing law. It's a really harsh thing when a person loses the benefits that they're depending on just because they get an inheritance from mom and dad. You know what I mean? So easy thing to protect against. You can only do it with the trust. Creditor protections. I don't mean to single anybody's family out or anything, but it does seem like in about every other family, there's that one person who maybe shouldn't get their share outright because they're making bad life choices. You've got the one that has the gambling problem or the drinking problem or the drug problem, or simply what I call the spendthrift. You give them $5 and somehow he manages to spend it. It's not a good money manager. You can use a trust to protect those beneficiaries from themselves by simply putting their inheritance in the hands of somebody you do trust to dole out how and when they get it. And you can do some pretty neat things in how you structure that if you care about very specific things. I'll get to that in a second. Divorce protections is a very common concern of farm families, particularly farm mothers. Farm mothers just don't like their daughters-in-laws or sons-in-laws or what, but situations where they worry that if I pass the farm to my son and he gets a divorce, is his wife going to get that farm? How do we protect that from happening? Well, if you use a testamentary trust, the kid gets to enjoy all incidents of ownership of that property without being the actual owner, because it's in trust for that child. So if they end up getting a divorce, the child's spouse can't get it because he doesn't own it. So little things like that you can get using a trust is far better than just passing the assets on, right? This is my favorite one, values promotion. I had a client one time that was worried about, he had a very, very goodly nest egg. He had very successful in the millions. And he wasn't particularly pleased with the motivation of his kids to get out there in the world and make a living. They were young adults at this point in time, in their early 20s. He just didn't see the fire in their bellies, and he was just afraid that if he died and his kids received this inheritance, they'd be nothing but worthless lumps on a log, and they would never work an honest day's living after that. So the value he wanted to promote is hard work. How do I give them something valuable without encouraging them to be lazy? And through some creative back and forth, we came up with a plan in which, in a given year, the beneficiary, his children, only got from their share an amount equal to what they made in that year. So if they were just going to flip burgers for the year, the amount they'd get from that trust would only be a comparable amount. If they were going to go make something out of themselves an education, generate a real livelihood, they can get a lot more out of their trust because they're proving that they can fulfill dad's wishes, earning a living. That makes sense? With hard work comes great reward. Excellent values promotion. So if you have something you want to encourage, a common concern in farm families, I've had families regularly bring up the concern that, how do I prevent my kids from just running out and selling the farm? Well, they moved off the farm, they want nothing to do with it, but that farm's been in our family for three generations. I'll be damned if I'm the generation that loses it because my kids didn't understand the value of owning that property. They just looked at it as another thing with a dollar sign. So what we'll often do is a plan that says these core assets that we want to protect and make sure the kids don't run out and sell it, we will take those parcels of land or whatever it is, the family business or whatever, we will stick that in its own separate trust after death, and we will provide the income to those kids so they can see how easy that money comes in every year from the cash rent or whatever, but they're not able to sell it. They just get the income for either a period of years or for life, or you get to decide, but again, we're promoting the value of holding the real estate because the good Lord isn't making any more. Powerful tool. You have a lot more flexibility in your plan than you're using the trust. All right, now we're at the very tail end of this. This is where things get super boring. We already talked about a lot of this, so I think I can burst through it really fast. Taxation generally. Wish I had caffeine to give you. All right, federal estate taxes. I'm hoping you all have a tax problem. My guess is probably none of you do, but there is a 100% marital deduction. So if I had $10 billion and I died today, and I gave it all to my wife, there's no taxes on it because spouses get to inherit free. However, as it stands right now, it's 11.7 million that can pass to other people, and each spouse has that. So right now you can have a $22 million estate if you're a married couple, and you'll never have to pay any federal estate taxes. Pretty remarkable. But the taxes for everything over that are pretty high. It's 40% of all amounts over that taxable threshold. If you have a married couple and one spouse dies, you do have to file an estate tax return if you care about using that first spouse's credit. So the way that works is one spouse dies, you file a tax return for that first to die, and then the surviving spouse can take the entirety of that credit and add it to their own when they die. So as it stands right now, if you die before 2025, you'll be able to tack $11.7 million onto whatever the credit is at the time you die by absorbing your spouse's credit. That make sense?
You got about 3 minutes.
Oh, that clock is a little slow, huh? Okay.
7:50.
Is anybody else in here from Nebraska? I think we lost our one Nebraskan hold on. Spouses have unlimited, just for the benefit of anybody listening online, spouses have unlimited exemptions in Nebraska. Lineal descendants, siblings, and their spouses, the first 40,000 through the end of this year, after the first of the year, it's $100,000 is exempt. So if you have 300,000, you have 3 kids, there would be no inheritance tax owing in Nebraska because each child gets that exemption on and after the first of the year. But the tax rate for everything over and above that is 1%. Everybody else pays taxes at a much higher rate. So if you don't have direct descendants and you live in Nebraska, anticipate that your assets are going to get hit a lot harder. After the first of the year, it's $40,000 that you get to exempt per person, and the tax rate is 11%. So it's kind of harsh if you're giving to people who aren't your children. 1% is really kind of an annoyance. But if you're given to somebody who is further out in the family or unrelated, you really get pounded good. If you're not family at all, the tax rate is 15% after the first of the year, and the exemption is only 25%. Anybody have property in Iowa? Iowa has its own framework. I'll put this up there for anybody who wants to see the slide, but I think we can move on. So, does anybody want to cover anything else in the last couple minutes? Any questions? What else you want to know about?
How does the inheritance tax work if your family is from Nebraska and say I live in South Dakota?
So it's based on the assets that the deceased individual has in the state of Nebraska. So if you inherit maybe a piece of real estate from Nebraska after your family member passes away, your share of that inheritance will still be subject to that inheritance tax. So as part of the estate administration in Nebraska, they have to file an inheritance tax, essentially like a return, but it's filed instead of with the IRS or the Department of Revenue. You file that with the county court, and they have a return formula, like a smart spreadsheet. So you plug in all the information that kicks out for each beneficiary what the taxes are, and then each beneficiary. You can do one of two ways. The estate can pay your taxes for you before they make your distribution, or you can get your share and then you have to pay your portion of that to the county. Depends how they decide to do that. If it's more land than cash, sometimes it's easier for the person who's administering, just give you your property and say, oh, by the way, somehow, some way, come up with this amount and give it to the county. That's
Always have inheritance tax.
as long as I've practiced law, yeah. There's consistently been a move to try to get rid of death-related taxes in Nebraska and Iowa. And Nebraska was finally successful in reducing it a little bit. You saw the comparison numbers up there, but they still have it. It's pretty entrenched because I think each of the counties depends on that revenue because it's paid to each county, not the state coffers.
Right.
Iowa did successfully pass legislation to get rid of theirs, but it's a phased out inheritance tax wind down. So every year until it's gone, it will get 20% less, I believe. So in about 3 years, I believe 3 or 4 years, it will entirely go away. So hence I don't feel too bad blowing past the Iowa stuff. Anybody else have any follow-up? I have business cards if anybody does want to sit down and have a more dedicated conversation. And as I said before, if you do want to have a personal conversation about estate planning, we don't charge at our office for those initial consultations. So there's no harm in sitting down, asking questions, and exploring your options. If you decide not to do anything, it's no skin off your back.
May I have a card?
I'm giving a card to everybody but Ken. Thanks for coming, everybody. Hope you like them.
I know.
I like to recommend